Hi, I'm Michigan Attorney General Dana Nessel. You may have heard about some new litigation which could affect the legality of reproductive health care in America. And I wanted to take this opportunity to provide some background on the situation as it's unfolding. An anti-choice organization in Texas called the Alliance for Hippocratic Medicine filed a lawsuit against the Food and Drug Administration in November seeking to repeal approval for two abortion medications, mifepristone and misoprostol, which are often prescribed together as an alternative to surgical abortion or early miscarriage care. If the anti-choice organization prevails in this suit, access to abortion medication will be eliminated nationwide, including in states which have issued their own abortion protections, such as here in Michigan. My office signed on to an amicus brief in the case led by the New York Department of Attorney General, opposing this egregious affront to states' newfound authority in the wake of Dobbs, which delegated the legality of abortion to each individual state. This attempt to effectively ban abortion nationwide is just as dire, if not more so, than what we saw last year, because medication abortion accounts for over half of all abortions occurring in the United States. These medications have been used for 23 years in over 5.6 million instances and have never been proven to cause medical complications. This attack on their efficacy does not claim any scientific backing. It is a purely political lawsuit that flies in the face of recommendations from the American College of Obstetricians and Gynecologists, the American Academy of Family Physicians, and the American Medical Association. Without access to these medications, women seeking abortion or miscarriage treatment will have less access to the care they need, will face further stigmatization of a deeply personal medical decision, and will be subjected to increased risk of lethal complications such as sepsis. New developments are arising out of these two cases every day, causing the resurgence of an all too familiar chaos and confusion among states, medical professionals, pharmacies, and reproductive healthcare patients. If this case allows political influence to overtake scientific expertise in determining the FDA approval for abortion medication, it sets a very dangerous precedent that would inhibit future medical advancement. In the hopes of preventing Judge Kaczmarek's ruling from becoming a unilateral end to reproductive health care nationwide, attorneys general, such as myself, have sought out other avenues to protect care. And that's why I joined Washington in a separate suit against the FDA, seeking to preserve and bolster access to mifepristone. This case was filed in the Federal District Court in the Eastern District of Washington over the weekend. The plaintiffs in this case represent over 59 million Americans and are seeking to prevent the FDA from inhibiting access to mifepristone, as well as to eliminate restrictive and unnecessary risk evaluation and mitigation strategy, or REMS as they're known. REMS are usually only applied in dangerous substances that carry a risk of misuse or adverse outcomes. Mifepristone is proven to be safer than blood thinners, erectile dysfunction medication, penicillin, Tylenol, and aspirin, none of which are subject to these restrictions. So what does this mean for Michigan? Well, this repeal of FDA approval would affect patients, pharmacies, and providers all across the country, including here in Michigan. If mifepristone is taken off the market immediately, as the plaintiffs in the Texas case seek to do, the alternatives are either a misoprostol-only regimen, which is a less effective and higher risk option, invasive surgical abortions, or the outright denial of necessary health care. Our state's northernmost facility capable of providing surgical abortion and miscarriage treatment is in Flint. Residents in northern Michigan, including the entirety of the Upper Peninsula, would have to travel to receive medical care, which is oftentimes very urgent. In neighboring states without abortion protections, women would be forced to travel to places like Michigan to seek out care, likely overcrowding our clinics more than they already are now, and increasing wait times for everyone. Neither my department nor the governor intend to waste the resources of our offices to go after patients and providers for the dispensation of safe and legal abortion medication. But the way this battle is shaping up, the authority may be out of our hands. The politicization of our courts undermines their authority. Our justice system was never designed for a single district court in another state to impact millions and millions of residents' healthcare decision the way that this decision has the power to do. Ultimately, this issue will have to be resolved by a ruling from the United States Supreme Court. And in the meantime, I will continue to use the power of the Michigan Department of Attorney General to protect the health, safety, and well-being of our state's residents in any way I possibly can.